Good afternoon, ladies and gentlemen. On a weekly basis, the South African Bar Association hosts an esteemed speaker to deal with a legal topic. This is an initiative aimed at making an essential contribution to developing the skill set of all and any persons who represent the South African public in our courts. It is my honor and privilege to introduce today's speaker. Our speaker today is Advocate Arnause Mohlala. By way of providing a brief background of Arnause, he started working at the trade union official. Thereafter, he joined City Power Johannesburg as an ER manager and later BHP Bulletin. Subsequently, he has joined the Ccma as a Level A commissioner and later appointed as a senior commissioner and a convening senior commissioner for the East Rand. In November 2018, he joined UNISA as a Director Labour Relations. Thereafter, Arnause has joined the bar. Arnause shall be addressing us on the topic titled Managing CCMA Processes and How to Resolve CCMA-related Concerns. In terms of housekeeping, these sessions are recorded and appeal to participants to ensure that your microphones are muted and that your video cameras are switched off. Should a participant have a question, simply raise your hand. Alternatively, type your question within the chat box using the Microsoft Teams platform, and such questions shall be posed to Arnause. During the question and answer session, a humble request is made to restrict questions to the speaker relative to the topic under discussion, and only pose such question when called upon. Without any further ado, I now hand it over to Arnause. Over to you, Arnause.
Thank you very much, AJ, for this opportunity. Firstly, I would like to acknowledge...
I'm just going to interrupt you. Please forgive me. Your camera is switched off. Perfect.
Okay.
Thank you so much.
Thank you very much, AJ. I was saying that firstly, I would like to acknowledge some of my former CCMA colleagues who have also joined the bar. Some of them, they came before me. Salele Molotsi SC, I acknowledge Dira Matlate, as well as I think I've seen Lekau, and as well as the members of the South African Bar Association. What I will do here, in regards to the members of the South African Bar Association, I must really also acknowledge Badford. He's also a former CCMA commissioner. And let me share here. Okay. The presentation that I will be doing here. Just hold on a sec, AJ.
I have shared it for you if you like, or would you like to share it by yourself? You muted now, sorry, Arnause. Arnause, you muted now.
Thank you, AJ. What we'll be dealing with today is that we are dealing with how to manage CCMA processes, and if you have got any concerns that you have when you are at the CCMA, how to resolve those related concerns. The issues that we'll deal with, AJ, the next slide, just as a summary of what we'll be dealing with is what is the role of the CCMA, and that is broadly, and which parties can refer matters to the CCMA. The next issue we'll be dealing with, and which matters are typically referred to the CCMA. The next matter is when is legal representation allowed? This is a concern, obviously, for people who are attending this seminar today. And the next is how to bring an application, whatever process that you may be interested in. And there is a concern that of perceptions of parties being bullied by commissioners to settle cases at the CCMA. How do we deal with that? When you are representing a party and you feel that you are being bullied or your client is being bullied to settle a dispute. Then we'll also deal with cost orders, then arbitration, and then the last will be if there are any complaints arising, how do you deal with those complaints arising in or during processes? Thanks, AJ. Firstly, the role of the CCMA is to resolve labor disputes through conciliation and arbitration. So that is the primary role of the CCMA. Briefly, it's to deal with how to deal with disputes in conciliation and arbitration. There are various ways that the CCMA deals with that, conciliation, mediation, arbitration, various interventions that are dealt with, as well as facilitations. Thanks, AJ. Who can refer matters to the CCMA? Employees on their own can refer matters to the CCMA. Trade unions on their own can refer cases to the CCMA. They can refer cases to the CCMA on behalf of employees and as well as on their own as trade unions. There are matters where a trade union on its own can refer a case to the CCMA. There are also limited instances where an employer may refer a matter to the CCMA. For example, this is very limited instances, and one instance that I can recall offhand is in regard to Section 189A, capital letter A cases, that is mass retrenchments. That's where in certain instances, the union may refer a matter, and in certain instances, the employer themselves may refer such a matter to the CCMA. Okay. Matters that are typically referred to the CCMA are unfair dismissals. This will constitute about 86% of cases that the CCMA deals with. Then the rest is a tiny percentage of cases that may be referred to the CCMA. Unfair labor practice, unfair discrimination, BCA entitlement disputes, and collective bargaining related disputes. Collective bargaining related disputes will be matters of mutual interest, especially where trade unions and employers are involved. In fact, that's where trade unions and employers are involved. Those will be related to wages and other conditions of service. Those are the typical matters that the CCMA will deal with. Now, as of interest to people who are attending this is which matters is legal representation allowed. Let's start first by saying one process where legal representation is not allowed. It's at conciliation proceedings. I will later deal with as to in what instances can a legal representative be allowed in a process. Now, to guide legal representatives, attorneys, and advocates as to when do you know whether you can represent or not, that is governed by Rule 25 of the CCMA rules. It will help you to clarify which matters you can or you cannot be able to represent a client. Now, if a dispute is about the fairness of a dismissal, and it pertains to conduct or capacity, legal representation is not automatically allowed. That does not necessarily mean that it will not be allowed, for instance, as in conciliation, but it may be there are instances where legal representation may be allowed, and then it depends on certain considerations by a commissioner. Let's see what those considerations the commissioner will have a look at. And the commissioner will have a look at what is to grant a legal representation. A commissioner will look at the nature of questions raised in that dispute, whether it's a complex matter, whether it's of public interest, and what are the comparative ability of parties at any given point. For instance, if the employer is represented by a very experienced HR manager, ER manager, the commissioner and the employee is not well versed in ER or in labor law, a commissioner may, in those instances, allow legal representation. Of course, depending on application made to that commissioner, and I will address that at a later stage. What is of critical importance here is that parties on their own, if both parties are legally represented, they may agree, they may give their consent to have legal representation. In many instances, the commissioner will agree that he will grant that representation if parties agree. They've consented to legal representation. The commissioner will agree. However, please be aware that the commissioner, despite the fact that parties have agreed to legal representation, the commissioner may still say no, depending on the questions that we have, the considerations that we have dealt with. If the issue is not of public interest, it's not complex, and when you look at the comparative abilities of the parties and say that this is, both parties can be able to deal with this on their own, and there are no questions of law raised, the commissioner may still say no to legal representation, despite that the parties have agreed to legal representation. Okay. And when is it allowed? When is legal representation allowed? No representation by legal practitioner or candidate attorney shall be allowed in facilitations of large-scale retrenchments. That is section 189A. And lay consultants are just not allowed to represent parties at the Ccma. Now, one party or some of the parties that may be allowed, automatically allowed to represent at the Ccma are trade unions, the employees themselves, etc. Which processes is legal representation automatically allowed? There's a whole list there, but as I've already indicated, this constitutes a tiny percentage of cases at the Ccma. The majority of cases that the Ccma deals with are unfair dismissals, as well as to a large extent, to some extent, incapacity matters. But this is a whole list of cases. For instance, 186A, this is unfair, some of the unfair dismissals. 1A to F, unfair dismissals. 186.2, those are disputes of unfair labor practices. Automatically unfair dismissals. Inquiry by arbitrator. Inquiry by arbitrator, this is a process where the parties can go to the Ccma and say that we don't want to do a disciplinary hearing on our own. We would like the Ccma to do this disciplinary hearing for us. And so the disciplinary hearing is disciplinary hearing cum arbitration, because now after the disciplinary hearing, which is dealt with by the Ccma, and is an arbitration, the parties cannot refer the matter back to the Ccma after the hearing. All that they can do, if there's a dispute, if there's unhappiness, they can refer the case for review at the labor court. Dismissals based on operational requirements other than 189, there may be legal representation there. 197 and 197A, transfer of business as a going concern or of a contract of employment in circumstances of insolvency. All disputes in relation to section 198A to C, all those may have legal representation may be allowed. BCEA, 73A, that is failure to pay any amount in terms of national minimum wage, contract of employment, sectoral determination, or collective agreement. However, in these instances, there are certain thresholds. To those people who are, I can't recall now what is the threshold determining referral to the Ccma. Those who are in senior positions, 300 and above, 300,000 and above per annum cannot have those dealt with at the Ccma. And the Employment Equity Act, Section 10, unfair discrimination cases can be, legal representation can be allowed in those instances. In conciliation, as I've already alluded, legal representation is not allowed, but you may request as a legal representation attorney, advocate, candidate attorney, or people advocate, you may request to represent a party in conciliation, especially if you have a mandate to settle. Those who are commissioners will tell you that there are instances where if they know that this party settles cases and is an attorney or an advocate, they will allow that party to, or if they assist in the process, they will allow that attorney or advocate to represent a party at conciliation. Just go back a bit, okay, thank you. A client can be given an opportunity. This is important for legal representatives to tell their clients that if I'm not allowed into a process, conciliation process, please note that you don't have to take a decision on your own. Consult with me at all instances. So your client, when faced with whatever that is being discussed with the commissioner, can say to the commissioner, Commissioner, I hear what you are saying on this and your advice on this. Can I have a discussion with my representative? Now, there are instances where, because we know as legal representatives that the Ccma doesn't allow for legal representation at conciliation, we say to our clients, you can go because we are not allowed. My advice is that go so that your client can have somebody that they can be able to consult with, so that whatever decision that they take, they can be comfortable that they have had your advice as a representative. The other issue is that your presence as a legal representative may prevent this bullying that you are talking about. If a commissioner knows that the legal representative is present and the client can always go and talk to the legal representative, then instances of bullying, then they get seriously minimized in those instances. Thanks. And what happens if legal representation is denied? What you can do as a legal representative is that you may request the arbitrator that, Commissioner, I would like to sit in this process. Arbitration is it occurs in an open court, so it is a public process. So you can request to sit there and observe what is happening. Now, the advantage of that is that from time to time, when parties take a break, then they can be able to go, you can be able to go and talk to your client as to how to proceed at any given time point regarding or in the process of arbitration. Now, I would like to warn legal representatives that when you are there, don't try to communicate in whichever way or form with your client, or make certain gestures of approval or disapproval of whether it's your client or the other party. Because the other party may say to the commissioner, Commissioner, this is what the legal representative is doing, or the commissioner may see what you are doing and you'll definitely be kicked out of the process. Thanks, AJ. Rule 31 of the Ccma rules determines how to bring an application. And it does the same way that you bring an application for legal representation. However, legal representation can also be made on the day of the hearing. You can go there and ask the commissioner, I'm applying for legal representation. It's advisable to apply for legal representation prior to the matter being heard. And those are issues where or matters where this rule applies, Rule 31, in terms of how to bring an application. It applies to applications for condemnation, joinder, substitution, variation, rescission, and postponements, jurisdictional disputes, or other preliminary or interlocutory applications. As well as it's apply 14 days prior to the date of the hearing on notice to all persons who have interest in the application. And now I'm not going, next slide, AJ. I'm not going to spend too much time on this one, on how to bring that an application, because application on notice is more or less the same, whether it's at the labor court or magistrate court, at the high court. For instance, the title of the matter, the case number, and so on, the relief sort, and so on. Next slide. Next one, that is just an application on notice. When you are in the arbitration now, and the commissioner makes certain rulings that you object to, that you are not happy with, make your objections known to the commissioner and make them on record. That commissioner, I'm unhappy with this or that ruling that you have made. Please don't tell the commissioner that, commissioner, I'm not happy with the ruling that you are making. I'm going to take you on review. That's a right that you have. You honestly don't have to tell the commissioner or threaten the commissioner that you'll take him on review. I think my view is that you're unnecessarily just straining the relations in the process itself. Now, the next issue is that don't tell the commissioner that you are going to apply for review of the particular ruling that the commissioner is making. If a commissioner is making a ruling that you don't like, and you say to the commissioner, can we stop the process right here? I want you to take this ruling that you've made to the labor court on review. Don't do that. There is a case that I can't recall now where it's precedent that you can only do that once the whole matter is done and finalized. Thank you. Now, a settlement is a very important process at the CCMA. There are certain efficiencies that the CCMA has. And one of the critical efficiencies, and that those efficiencies are determined by management of the CCMA as well as the governing body of the CCMA. So it's a critical thing for the CCMA to see a high percentage of cases being settled. And the settlement rate at the CCMA, for some of those who may not know, is 70%. So a commissioner is required to settle about 70% of cases that he or she deals with. This is why then you will see, so it's a requirement of the CCMA that you need to settle about 70% of the cases. And an advantage to the commissioner is that if a case is settled, they don't need to write an award. Now, for the purposes of the CCMA, commissioners are not paid specifically for an award. So whether you have settled the case or you've done an award, you don't get paid. Some of the bargaining councils, then they pay, but there's no payment for awards at the CCMA. At the time that Advocate Ford was a commissioner at the CCMA, awards there was money for, there was an incentive to pay for awards, not anymore. So therefore, there's an incentive for commissioners to try to settle as many cases as possible, because if you don't settle those cases, it means that they have to be arbitrated and an award issued. Now, if you see a commissioner pushing a little bit more than you would like, you just know that commissioners have a certain requirements to meet. However, you have a right to say, Commissioner, we hear what you're saying, but we don't agree. We don't want to settle. In fact, as a matter of fact, right from the beginning, you can say, if you don't have a mandate, if you believe that you have a very strong case and you don't want to have it settled, nobody can force you to have a settlement, unless the settlement is, if the other party, for instance, if it's an employee, if the employee says, no, I withdraw the case, that's fine. That is a settlement as well. If the employer, when they get there and they then have thought about the matter, because now they are at the stage of arbitration and they now want to have thought about it and say, okay, we want to settle at 12 months. It's possible. The employer can settle at 12 months or even more. There are instances where some of the people who are here who have been commissioners, they will tell you that there are instances where the employer has settled more than what the Act prescribes, that is 12 months. And if in instances where the commissioner gets into the merits of the case, because they like to have it settled, and they get deep into the merits of the case, they get so deep into the merits of the case, and to the extent that they say to the parties, whether to the employer that we think that you are going to lose this case. And here our reasons, I believe as a commissioner that you are going to lose the case. Or they say to the employee the same thing, that we think that you are going to lose this case, and for the following reasons. If the employer does that, they have gone deep into the merits, and there's nothing wrong with that. They have to recuse themselves. Some commissioners will recuse themselves on their own. Others will have to be asked that, Commissioner, thank you for your views, your opinions, your advices on this. However, considering the fact that now we're going into the arbitration proper, we request you to recuse yourself because we think there's a big possibility of you being biased here. In many senses, commissioners will agree to recuse themselves. They'll agree to recuse themselves in such processes. And if not, if they don't recuse themselves, then ask for the intervention of a regional senior commissioner or provincial senior commissioner. If both disagree, I mean, the commissioner, the regional senior commissioner, at the time, if they insist that the commissioner must proceed, put your objections on record. Because at the time that you will be conciliating, mediating the matter, you will be off record. Then ask the commissioner that, Commissioner, prior to us starting with the actual arbitration process, I would like to record my objection in regard to the issue of your refusal to recuse yourself in this process. Now, when you are in smaller offices of the CCMA, let's say, for instance, Roblesdal, then always or Secunda. No, Secunda, there are many commissioners in Secunda. Smaller towns where there's one commissioner available at the venue. Try not to get into the merits of the case, because you are not going to have to be afforded an opportunity of somebody else being available. If you are in the bigger centers of the CCMA and like Johannesburg, Pretoria, Bloemfontein, and so on, then you've got the luxury of, or they have the luxury of asking somebody else to take over the matter. But if it's a smaller place where there's one commissioner available, don't get too much into the merit. And you have the right to say, Commissioner, I don't want to get too much into the merit of the case. The commissioner cannot force you to get into the merits of the case. AJ? Order for costs at an arbitration. I was a commissioner for more than 10 years. However, honestly speaking, I cannot recall more than 3 times where an order for cost was awarded at the CCMA. maybe even twice. So I really cannot recall. Maybe it's being done these days, but during past time, during my time, during Moloti SC's time, this was very, very rare thing. That is despite the fact that the LRA has always had a provision for order of cost in an arbitration. The commissioner may make such order depending on certain factors, and those are then, that is Rule 39 of the CCMA. What is the measure of success, consideration of fairness, any prejudice offers that were made with a view of settling the dispute, whether a party or person who represented that party in the arbitration acted in a frivolous or vexatious manner. Frivolous and vexatious as a consideration, it has always been there, right from the beginning when the Act was enacted in 1996. Okay, thank you. Whether the party has conducted, how the party has conducted itself, what effect that cost order may have on continued relationship, if any. If there's any agreement to be concluded between the parties in regard to costs, importance of the issues raised, any other factor that the commissioner may consider. And that is, a commissioner may make an award of costs in favor of a party who appears or is represented in arbitration by a person contemplated in Rule 25. Here we are talking about legal representatives, so it may, cost orders may be made. The commissioner may make, AJ, next slide. Though the amounts for costs are quite limited. They can be limited by the CCMA in terms of the rules, in terms of Rule 2039. So those are the limits of how much can be ordered or cost that can be ordered in a particular arbitration. 7,000 rands of the first day of arbitration. And if the arbitration goes on longer than a day, any additional day will be 4,700 rands, inclusive of VAT. Now, candidate attorneys can only claim 50% of the amounts that are set, of 7,000 rands on the first day and 4,700. What I'm not sure now is people advocates. I'm not sure because the LRA doesn't say. I mean, Rule 39 doesn't say anything about them. The last issue that we'll deal with is what do you do if you have complaints of whatever nature, but not rulings. If a commissioner makes certain rulings and you are unhappy with such rulings, it's not going to assist you to go and complain to a provincial senior commissioner. But for instance, a refusal to recuse oneself as a commissioner is one ruling that may be referred to a provincial senior commissioner. So you can always say to the commissioner at the given point that, Commissioner, I'm not happy with this kind of ruling. If it's a ruling, sorry, just a sec. If it's a ruling that you believe an intervention of somebody senior can be able to deal with, you say to the commissioner, Commissioner, can you please stop the proceedings now? I need to complain about this and or that to the provincial senior commissioner. And in the absence of a provincial, in fact, before you speak to the provincial senior commissioner, these days, there's what is called the Regional Senior Commissioner, RSC, and then there are higher than RSCs is Provincial Senior Commissioner. In certain instances, you may pick up a phone if you know the telephone numbers and speak to the National Senior Commissioner of the CCMA, the director, depending on the issue. You may even complain to the director of the CCMA, write an email if it helps, or if it's an ethical issue, you may even write to the governing body of the CCMA. Depending, honestly speaking, just depending on what kind of issue that you like it to be dealt with. Unfortunately, we don't have space, or we didn't have space to give telephone numbers of those people that you can complain at. But this brings to the end the presentation, and thank you very much.
I thank you for that informative address, Arnause. I have now opened the platform for a brief question and answer session. To those that have a question, simply raise your hand, and when your name is called upon, simply allow your mic and or your video to pose your question directly to Arnause. Alternatively, type your question within the chat box using the Microsoft Teams platform, and such question will be put to Arnause. I shall initiate the question and answer session. My question, Arnause, surrounds condemnation. Now, we are all familiar with the fact that an employee has 30 days post-termination to apply to the CCMA, failing which the employee needs to apply for condemnation in that regard. Upon our prior telephonic discussion, rather, you had mentioned a certain judgment that said something to the effect that that condemnation should be granted in circumstances where the employer's conduct against the employee is done in mala fide. Can you please elaborate on such?
I'm going to ask you to repeat the question, AJ, but what I will also need in terms of the questions and answers. There are a lot of capable people here, and I deliberately mentioned them when we started with this process so that they can also participate. Molotsi SC is here. He was one of our speakers before. Matabo is here, and Matache. They can all assist. But can I request you to repeat the question, please, AJ?
Sure, Arnause. So in summary, upon our previous, my question is to do with condemnation. Now, upon our previous telephonic discussion, you mentioned a certain judgment that said something to the effect that that condemnation should be granted in such circumstances where the employer's conduct against the employee is done in mala fide. Can you elaborate on such judgment, Arnause?
Okay, colleagues, I'm inviting you to participate in the questions and answers. Advocate Matlatle.
Yeah, if I may, Arnause, I'm speaking on AJ's computer. I'm not sure, can you hear me? It's Bart.
Okay.
So there's a decision called Causa and Absa Bank. And what the Labour Appeal Court said insofar as dealing with condemnation is that in all matters pertaining to condemnation, the interest of justice will always be the most important factor to consider. Look, when one deals with condemnation, obviously there are a number of factors that or considerations that one would need to deal with. But what the Labour Appeal Court said in the Causa Absa Bank decision was the interest of justice, because should condemnation not be granted, it would in effect mean that the doors of justice, so to speak, would be closed upon the employee. And in fact, there's an important note in that judgment, but the court said how would the interest of justice be served by denying an employee condemnation? In fact, granting condemnation would serve the very purpose of promoting the interests of justice as opposed to denying the employee access to condemnation.
Some of the factors that the court has looked into and considered in regard to whether to grant or not grant condemnation is the prospects of success. If the prospects of success, if the court looks at the papers and the application and considers that the prospects of success are quite good for the applicant, then there's more likelihood that the court grants condemnation. One of those obviously is how late the application for condemnation is. But that as Advocate Ford has said, that the court also looks in the interest of justice. It looks as to the reasons why is that application late, and also the factor that I have mentioned here as to what are the prospects of success in that matter. Then the court is likely more to grant the condemnation.
Thank you so much. You have
and the Ccma, of course.
Thank you so much.
Can I just come in there?
Sure.
Can I just come in?
And that's Advocate Mohlala.
Sorry. My name is Advocate Mohlala. I think what Advocate Mohlala indicated holds truth. In most cases, the recent cases that I have read, they indicate that the prospects of success and the lateness. However, if we have to have a look at all them, basically the court has to take, or the commissioner has to take all the factors into consideration. So cumulatively, you can take it into the imagine a situation where you can say, well, it's in the public interest and blah, blah, blah. But where really you can just see there are no prospects of success and the matter is excessively late. You know, the matter is, and the interest of justice, remember, it's a very elusive term. I mean, if a person brings the case 6 years late, you know, so it's excessively late, it's late. And then you look at the interest of justice that, listen, there might not be witnesses and there's stuff like that. But I think the guiding principle should be that you look all these factors, take them into account. But as I said, the recent judgments that I have read, they tend to put more emphasis on the factors that Advocate Mohlala has indicated, the prospects of success and the lateness. But that does not mean that it's at the expense of others. The very recent case that I've read, they said, listen, if there are no prospects, what is really the point of going into so much pain of condoning the matter? Thank you.
Thank you so much for that. Sorry, I got my second question is pertaining to, and you briefly touched on that, Arnause. This is pertaining to the Section 189 applications, right? Now, my submission to you is that during this COVID, especially during this COVID time, employers are using the Section 189 merely as a ruse to dismiss employees. Would you say that what would be a comment in that regard?
I've had experience of employers doing exactly what you are saying. Second, not employers. Let's be very specific and clear that, and not generalize that it's all employers that are doing that. My experience is that I've seen and experienced employers using the cover of COVID-19 to retrench. And now The issue is whether at any given point the employer is able to justify the retrenchment. So if an employee is not happy with the reasons that the employer is giving as to the reasons of the retrenchment or dismissal for operational reasons, the employee can always refer the matter to the CCMA. Depending on the number of people involved there, the matter can be referred to the CCMA, or if the number is quite significant, to the labor court. And so the court, the CCMA, will look into the real reasons, whether those are fair or not, because dismissal for operational reasons, they are also subject to a consideration of the fairness, whether it was fair or for the employer to raise as a reason retrenchments or not.
Thank you so much, Arnause. You have answered my two questions. There's a question from Advocate Bart for
Advocate Mohlala and colleagues. So the circumstances are briefly as follows. I hope you can hear me.
My sincere apologies for that, Bart. I think we have lost Arnause. Can we just have a brief?
Yes, sorry.
Are you back with us, Arnause?
Yes.
Thank you so much. Back to you, Advocate Ford.
So the question, Advocate Mohlala, is the following: the circumstances briefly being the commissioner bullied the employee into accepting a settlement agreement, but the settlement agreement is nothing other than what the employee would ordinarily have been entitled to, i.e. leave pay, notice pay, and a bonus. So the employee signs that, thinking that in doing so it has included a bona fide agreement, but it does not constitute a bona fide agreement for public policy considerations to sign a settlement agreement, which is an entitlement to what you, well, an agreement in respect of what you're already entitled to. How would you advise an employee to deal with his or her discontent in that regard?
Thanks, Advocate Ford. There was a policy decision, at least when I was there at the CCMA, or when we were there with Advocate Molodzi. There was a policy decision that what you have just described now wouldn't be regarded or considered as a settlement. That's an entitlement. That's what the employee is entitled to anyway. Now, it's one of those where we would have said that the employee, when unhappy with the outcome, can refer or can lodge a complaint with the senior commissioner. I'm not sure now how the CCMA deals with. At the time that we were there, what we'll do, if satisfied, if the senior commissioner is satisfied that these are the elements that constitute the so-called agreement, and we know that this is not an agreement, this is what the employee is entitled to anyway, the matter would still be enrolled for arbitration. If I recall, this is what used to be done. However, I think this is an area of possibility where an employee can be able to successfully review such an outcome or such a settlement and take it on review at the labor court. That's my thinking, at least now, that if the CCMA is not able to resolve this issue, on its own, considering that this is not a settlement. Everybody knows that this is what the employee is entitled to anyway. This is a matter that may be taken under review.
And just a follow-up question before the other speaker, Molotsi, as he speaks. What then would you say in as far as the CCMA being complicit? I know complicit is probably a very strong term, but I remember when I was interviewed by the governing body, Nareen Khan had asked me, how do I feel about the percentage issue pertaining to resolving disputes by way of conciliation? And I felt that the threshold set would, in all probability, result in commissioners resorting to unbecoming tactics in order to try and resolve matters so as to meet the threshold. And I'd like to know what your comment in regards thereto is.
Can I ask SC Molotsi to speak before I do on this matter, please?
Good afternoon, colleagues. AJ, can you hear me?
We can hear you fine, Nancy.
Yes.
Thank you.
Good afternoon, everybody. Arnause, thank you, my brother. Yes, I think you are correct on the first issue you raised in respect of during our time, there was that policy decision that any settlements relating to entitlements that are contained in the basic conditions of employment, particularly when the dispute related to unfair dismissal dispute and the settlement comprises of entitlements in the BCA, that was not a settlement. And I think the CCMA at that time went at great length to inform the employees by putting notice boards, in fact, even in the hearing rooms themselves, that they should not settle cases in respect of notices, leave, and all of that when they have referred an unfair dismissal dispute. So you are correct, Arnause. In respect of the second question of Advocate Ford, look, I think it's important to put this thing into a proper perspective, and which is that the CCMA at first believes in mediation, meaning that the CCMA at the time when we were there on us, we put mediation before arbitration, meaning that we wanted the parties to settle their disputes before they proceed to arbitration. Because we always of the view that in settling cases in mediation or conciliation, the parties, you determine the outcome rather than the arbitrator sitting there making a decision which will be binding to the parties. So because of that policy view, which I hope is still the case, then the CCMA then, in order to galvanize and incentivize the parties to resolve the cases, decided to put the settlement rate of the commissioners at the 70%. And really, it is not really about commissioners forcing the parties to settle. It's really about making sure that we live in terms of the LRA objectives, which is a speedy resolution of labor disputes. And I think part of trying to resolve cases in conciliation is really that you want parties to resolve cases in conciliation rather than going through a formal arbitration process, which in some instances can be a very difficult process, particularly for applicants who are unrepresented and perhaps at some stage also uneducated. So that was the policy rationale behind the 70%. But also the governing body, even during our time, Arnause, has always been, although they expect commissioners to reach 70% settlement rate, but they were always amenable to commissioners who were just below 70%, and also commissioners who were really not mediators, but mostly arbitrators, who you'll find that such commissioners, then their settlement rates will be sitting at about 50% and so. And the governing body really never really went into details or take issue with people who did not reach 70% settlement rate. But I think, I mean, speaking for myself, and I'm sure Arnause will bear me out here, as senior commissioners at that time, part of our responsibilities was to guide and assist who are not really reaching the target of 70%. And we were further mindful of the fact that those commissioners should not force parties to settle. And hence the CCMA at that time had an open door policy of complainants coming directly to the senior commissioner's office if they were unhappy with the process to complain about the outcome. And such interventions will be done to make sure that the party lives happy. So I don't think it's really a CCMA being complicit for it. I think it's really about putting mediation first and also leaving this objectives and spirit of the Labour Relations Act, which is speedy resolution of labour disputes. I don't think there's ever been a commissioner who would really be penalized because they've not settled the matter. Of course, it's a KPA for commissioners at that time. I don't know the position now. But even if the commissioner do not reach that KPA, there will still be other issues to determine whether the commissioner can be elevated further or be given a renewed contract. But really, it's about a policy decision of mediation first. Thank you, Arnause. Thank you, AJ.
Thank you so much, Arnause. And
James, can I say something on this matter? And just to say that we've been joined by another stalwart, former stalwart of the CCMA, Advocate Meli. My view is that I hear and acknowledge what Advocate Mohlala is saying, but my view is that the pressure. There's a huge pressure on commissioners to settle their cases. And I know this is a fact that during the governing body interviews, this question is always asked. If your settlement rate is below that 70%, there will always be a question as to commissioner, why is your settlement so low? And now, whether this is conscious or unconscious, there's a huge pressure on commissioners to settle as many cases as possible. Now, the issue is not, for me, is not about the speedy resolution of a case. The issue is social justice. And this is one of the considerations. At some point, the CCMA put together a commissioner or a mediation commissioner at every region that will look at to the quality of the settlement agreements. Because you will find instances where a commissioner settles a case with 200 rands or 100 rands. And because the employee at that given time is desperate to take this money, then they take the money, and that is regarded as a settlement. I believed and believe that that is wrong. And I believed at that time, SC, I believed that the settlement rate needs to be pushed low so that you concentrate more on the quality of the settlement agreement, far more than because it's mere settlement. Because the issue is not just being happy that the matter has been settled. The issue is about the quality of the settlement itself. This is an issue that my view is that, for instance, bar associations like us, South African Bar Association, we need to take up with the CCMA. It's something that we need to do to say that let's not focus on the fact that the matter is settled. What is the quality of the settlement that you have? Thank you.
Thank you so much, Arnause. I agree with you. And thank you so much, Mohlala SC. Thank you for that. There's a question by Makwela. Makwela, you can simply unmute your mic and or your video.
Thank you. Yes, it's Advocate Makwela, but I'm also a commissioner, current commissioner. I wanted to answer on the issue of settlement, where an employee has settled with monetary value or statutory monies only. I want to just highlight this, that we do arbitrate disputes where an employee had settled with monetary value only. There's a case law, it's Cook for Life. So CCMA has jurisdiction to arbitrate those disputes, because what will an employee normally say to be that I was put under duress to settle the dispute. So we look at whether the employee was put under duress, and whether indeed the dispute has not been resolved. Because if you're saying that I'm unfairly dismissed, but the settlement that I've signed is only with relations to monies that are owed to me, then it doesn't settle the dispute that that must be before the CCMA. I only wanted to comment on that. So Cook for Life is the case law that you can refer to. Thank you.
Can I just weigh in on this one? Just two comments. One, I think it has to be appreciated sometimes that when we are sitting in the commissioner's seat, it's not an easy task. You are confronted with the reality of life. And to this end, I'll say that you'll have the parties who will come to you after you have done all the reality testing. One, for example, it might be a possibility that when you look at this, Mr. X, what are you actually looking for? And then when you test the reality, in all honesty, assuming that in all fairness, said, no, this guy does not want to pay my pension or my UIF, which is not end. And you ask really that's all what he wants. Yeah? And then you might find that this person, in actual fact, he came to the wrong forum. You cannot say, no, go to labor. He said, no, I want to labor. This guy is troublesome. So you might find that genuinely that's what he wants. And at the second other instances where you find that in reality, when you do the reality testing, you check with the employee, after somehow you do the reality testing, he realizes that he does not have a case. Yeah. I've had one instance where the person actually came to work, was dismissed about 2-3 times under the influence. I said, but honestly speaking, what do you think? I was with him, the two of us. The other party is out. He said, our commissioner, honestly speaking, I was just taking a chance, man. Let them just give me my UIF, I'll go, you know? So in those kinds, let's not be very harsh to the commissioners. The question of bullying, maybe let me just leave it. It might be some other topics, but there might be the reality which faces the commissioner. In all fairness, you might well think that maybe it's unfair, like the instance that I just told you. Maybe the other ones I wanted to comment, I think that my colleagues have handled them. Thank you.
Arnause, there are many questions. Unfortunately, time does not permit for such, and regrettably, I have now closed the question and answer session. What remains is to yet sincerely again thank Arnause for his illuminating address and naturally for his time. Appreciation to all those that have participated and all those that have commented, including the various commissioners and Advocate Molotsi SC. Appreciation to those that have participated virtually and shall be watching this session at their leisure. These sessions are recorded, and the recordings can be found upon the South African Bar Association website, that being www.rsabar.net. I thank you.
Thank you very much.
Thank you.
Thank you, guys. Cheers.